Thank you for joining us today with Synergy's webinar titled Health Insurance Lien Resolution Partnering with an Expert. I am Teresa Kenyon. I am the Director of the Lien Resolution Department here at Synergy Settlement Services. I am a licensed attorney in California and Kentucky, and prior to joining Synergy over 3.5 years ago, I worked with the Rawlings Company on behalf of those health insurance carriers that are taking the settlement funds from the injured party. So I worked on behalf of the health insurance carriers for a subrogation vendor. We'll talk more detail about that later. But I've got a team of passionate fighters that have over 300 years combined experience in fighting these health insurance liens. Many of them also come from the other side. So we've got a good representation of the different tactics that are used with different subrogation vendors and health insurance companies. So let's go ahead and get started. We're going to focus on why it's a good thing to partner with a lien resolution company for your lien resolution needs. So these are two questions, or two versions of questions, that we sometimes get asked by plaintiff personal injury attorneys. The first one is, why should I hire an expert to assist in lien resolution if I can do it myself, or I can have my staff of paralegals handle it? And another question that we sometimes hear is it ethically permissible for me to partner with a lien resolution company, or do I have to do this myself? So we will hit on those two questions and the answers to them in the upcoming slides. So let's first talk about the responsibilities of a law firm as it relates to liens. So let's focus here first on tracking liens. I think it's generally accepted that a law firm must track or deal with liens that are asserted against their client's personal injury claim. Sometimes there is an affirmative duty to investigate and identify these liens, and that would certainly be the case with Medicare. I think that's pretty widely accepted. A little bit more under dispute for Medicare Advantage because some don't feel like Medicare Advantage plans handled by private insurance carriers like United or Aetna have the same rights as Medicare, but they do. They have the same rights and the ability to pursue double damages against anybody who would be seen as a primary payer. But really, like, the idea of a law firm needing to deal with a lien that is asserted, that's generally accepted, but there's definitely a pendulum as it relates to this. There are some attorneys who believe that they can bury their head in the sand and not address it at all if they think that there's not a right, but they don't do anything to investigate it. That's risky, but some attorneys are perfectly okay with risk. And then there are other attorneys who absolutely want to identify and deal with and get closure letters and all of that on every single possible stone as it relates to a health insurance lien. And those are generally attorneys who are not risk adverse and they want to make sure that they're doing all the things. So really, I mean, all kinds come to Synergy, and we do adopt a lot of what action we take on a particular file based on the comfort level of the attorney that we're handling the lien for. We advise what is recommended, and then we take the direction from you. So the other important thing, and that is a responsibility of a law firm, is to determine the validity of a lien holder. You all know that oftentimes a lien holder will try to join the table, right, the settlement table, and stake a claim to get recovery dollars to reimburse their lien from the settlement fund, and they've got no business being there. So determining the validity of the lien is definitely something you want to do on the very front end, certainly before you begin any negotiation. So what does it take to determine the validity? A lot of time, usually. So it does require significant contact and interaction with the lien holders, with the subrogation vendors, with the self-funded employer groups, with the government agencies, just all of those things to make sure that you really do know what kind of lien this is and that you understand what kind of right they may or may not have. Many of these recovery vendors have very specific policies and procedures, and really, like, understanding the differences between the recovery vendors on how they view a certain lien type or a certain plan is an important part to determining the validity. We here at Synergy often find that, say, Optum will pursue on a particular lien type and Rawlings will choose not to. So just kind of having that knowledge, really based on volume, is an important part to determining the validity, and then being able to make arguments on the side of the one that wants to pursue it because the other one didn't want to pursue it. Another thing to focus on and to make sure that you are aware of when you're determining the validity is it federal law or state law that applies to this particular plan? Oftentimes, one allows for stronger rights of the plan than the other, but really understanding what type of lien it is and knowing whether it's state or federal law is an important part to determining the validity. You want to make sure you're getting the proper documents, particularly if it's an ERISA self-funded plan. These subrogation vendors will pretty readily give you the summary plan description, the SPD, because it is what they update on a regular basis or what they have their clients update on a regular basis. But there are other documents that you want to be getting to truly determine the validity. And sometimes that takes time. Sometimes it takes going directly to the employer group. Sometimes it takes asking 10 times before you actually get what you need to determine the validity. And the final thing that you want to look at when determining the validity is the claim summary itself. You want to make sure that those claims that are on there as part of the lien should be there and the billing codes haven't been tinkered with or something like that needs to otherwise be corrected. So why partner with a lien resolution company? So as you probably already know, when you are resolving a lien, you are often dealing with a government benefit health plan or an aggressive recovery vendor on behalf of a private health insurance carrier. So the first instance is your government benefit health plans like Medicare, military, Medicaid. Those are your government agencies. They are often ineffective. It's time consuming to deal with them. It often takes multiple passes. You usually have to send the same document multiple times. It's hard to get a hold of a person. There's lots of red tape as it relates to dealing with government agencies. So why would you want to have to deal with that? You can certainly go ahead and partner with a lien resolution company and we'll do it for you. On the other side, there are private health insurance carriers who hire experts in their own right, and those are the subrogation vendors like Optum and Equian, who have now combined Rawlings and Conduent. There's plenty of smaller kind of defense firms, Discovery, Benefit Recovery Group. There's lots of different subrogation vendors, and really what to know about them is that they are big corporations all on their own, and they are representing even larger corporations in these health insurance companies. Also important to know that they exist solely to take money from a injured party's personal injury settlement. Like that is why these subrogation vendors exist. That's all they do, all day, every day, just like Synergy does liens all day, every day. They also have deep pockets, and they've got a large staff of what we call bounty hunters to pursue nothing but liens. So for those reasons, you'd want to partner with a lien resolution company to go ahead and take on the red tape of government agencies and then also the aggressiveness of the subrogation vendors or bounty hunters. So why hire a expert lien resolution team? We say that there's generally 3 reasons that you would do this. And the first one is to make your law firm more efficient by reducing operating expenses. You would be offloading the expense of paralegals or legal assistants or even yourself to another company, and it would then reduce your operating expenses as far as the payment of your paralegals and legal assistants. It also gives you a deep team of experts to fight these big recovery vendors. It might just be you and your paralegal that are trying to battle Rawlings and have a full understanding of everything that Conduent does. But by hiring an expert lien resolution team, you've got a whole bunch of people, a whole team of experts to know the ins and outs and to be able to push all the right buttons to make things happen. And then the third and final reason, and possibly the most important, is to get the best possible result for your injured client. My team is passionate about getting the deepest discount that they possibly can, the biggest reduction when they are talking with these recovery vendors and these health insurance companies. They don't want to pay $1 to them on behalf of your injured person. They are seeking waivers. They are seeking as little repayment as possible, and they are bringing all the arguments that they possibly can in order to make that happen. So let's talk about reducing operating expenses. This is really just all about allowing you to focus on what you and your firm do best, which is making moves to obtain settlements and get those winning verdicts, versus creating a loss to the bottom line by dealing with liens after the case. So really ask yourself, how many hours do your paralegals and legal assistants spend attempting to negotiate a lien? Really, how many hours do you as the attorney spend researching the law related to liens? At the end of the day, every business is looking to decrease their operating costs and to increase their efficiency. And so partnering with a lien resolution company as your lien expert allows that cost to be passed off as a cost to the client in most states, similar to the cost of retaining an expert. Many of our Synergy's clients do pass off our fee as a cost. Others absorb it as part of their contingency fee, certainly up to you, perhaps even a combination of the two. But this is certainly a way to reduce operating expenses by having an outside company do this lien resolution work, and it allows your paralegals and your legal assistants to get the next settlement. So the second reason to partner with a lien resolution company was to give you a deep team of experts to fight these massive recovery vendors and health insurance companies. Really, the recovery vendors' business model relies on plaintiff attorneys having their hands tied behind their back. And this is really just due to a lack of resources, a lack of time, and a lack of specialized knowledge as it relates to all the different types of liens and the laws that are associated with them. So these recovery vendors, they know it can be overwhelming, and they exploit that to their advantage. So you will often be told no, and then you ask again, and you'll be told no again. And then quite often, and I can tell you this because I worked on the other side, you give up and you pay them what they're asking for, or they give you a nugget. After they've said no a couple times, you feel defeated, and then they finally give you a little bit of a reduction, and in your mind, you're ready to get on to the next case. Your client is ready to get their settlement funds, and they don't want to wait for the lien anymore. And so the recovery vendor gets what they demanded. Here at Synergy, this is what we do all day, every day. And sometimes it does take time, and there's a lot of strategy that goes into time. Sometimes time is your friend. But what we don't do is give up after the first or second shot. And there are often times where we are going to the mat 10 times to get the deepest reduction possible. So I want to take a moment to just highlight Synergy's Lien team. So these are my people. These are the negotiators that are fighting on behalf of the injured parties, and we've got over 300 years of experience in fighting liens. Many of these people come from the other side, and as I said earlier, that's considered the dark side. But what that means for you is that we've got some insider knowledge. We know a lot of the internal policies of the different companies. One, because we used to work there, or two, because we deal with them all the time and we see the patterns and we know what's up. We know how the authority process works. So what that means is how much somebody can reduce a lien in their current role. So it might be the first person that you're talking to can only reduce a lien by 5 or 10%. If you are going to get more than that, it needs to get to a different person. Now, it might be that you have to talk to a different person, or Synergy's lien team, or it might mean that you have to convince the person you're talking to go talk to somebody else to get that reduction. So that's authority to reduce. Some of them are often very tied, and they don't have the ability to reduce directly when they're talking to you. They've got to go get approval. Many on my team that come from the dark side know what works because they used to be the ones that did it. I know oftentimes when I interview to bring people to my team, and I know that they've come from the other side, I ask them, what is it that works for you? What is it that makes you, when you're sitting in that chair over at Optum and over at Conduit, that makes you say, okay, I'm going to reduce this lien. Even though I don't have to, or even though I don't want to, I'm going to reduce it. So what is it that works? So Synergy's Lien team has a lot of that insider knowledge of what works. We also know how long it takes, and that is a key focus area, because you can get it done fast and probably not get a big reduction, or you hopefully allow it to take a little bit of time to marinate, let time work on your side, and then you're able to get the bigger reduction. One, because the other side finally just wants to get it done, but also two, because you have actually investigated and explored and exhausted all of the possible ways to get a deeper reduction. And the other thing about Synergy's Lien team is that we are full of collaboration and knowledge share. So often when we have a win, or even if we have a loss on behalf of an injured party where we don't get as deep of a reduction as we wanted for any number of reasons, we talk about it. We share that information amongst ourselves, and it makes each and every one of the Lien team members better for it. So just a ton of collaboration, which just increases the volume and the knowledge that we're able to have as individuals and as a group. So the third reason to hire a lien resolution expert to handle your client's liens is to get the best possible result. So as a lien resolution partner, we, as I've said before, work to resolve liens all day, every day. It is all that the lien team does, is focuses on these liens and getting them reduced as much as possible. With that, we see every potential lien resolution argument from the other side. We are also knowledgeable and up to date on the latest legal changes that impact liens, know when to push on those changes, or realize that the vendors or the person that we're dealing with isn't aware that those changes have taken place yet. We also understand the rules and the process changes that are made by these recovery vendors or these inside subrogation units. Because we're seeing this time and time again, we start to notice the patterns with certain companies that, oh, it looks like they're doing this month, or this appears to be an argument that's working, but this one is not. Along with that, we've got insider knowledge from our personal experience of having worked at these companies, but also our current contacts that are still there in these companies. So former employee coworkers that can kind of sometimes give the inside scoop. We also, because this is all we do day in and day out, know when to push and we know when to fold. So I can tell you from my time at the Rawlings company that if I got involved on a file as a team attorney and said no 2 times, I would probably just get whatever it was that I was asking for. It didn't take many times for me to push back before the plaintiff attorney or the paralegal on the other side just went ahead and decided it was no longer worth the battle. Here at Synergy, we also know when it's worth pushing and when it's worth stopping the push. And it's definitely more than just 2 times. I can tell you that from a lot of the conversations that I've got with the team and the group lien type meetings that we have to share this kind of stuff, to just be a real collaborative team. There are people that are taking 10 plus swings at a particular lien to get the best result for the injured party. And at the end of the day, that's maybe not something that you're able to do at your law firm. Again, going back to reducing operating expenses, but it's something that we do here at Synergy when it seems like it's going to really help make an impact. So I wanted to go ahead and give an example. This is a classic example of when you probably should get a lien resolution company involved. It's when there are multiple lien types. And the big reason for this is that each lien type has different lien rights. They've got different priorities that are associated with them, and really they just shouldn't be treated the same. It shouldn't just be that this is a health lien, and if I get this percentage of reduction on it, then all the other ones should also be the same, and then I'm good. Each one should be looked at individually. So a little bit of a case example here. We've got a client that's 65 years old that was involved in a motor vehicle accident, was covered by their employer-based health plan at the time of the accident. So we're going to call that an ERISA plan. There are exceptions to that, of course. They are now unable to work due to their injuries, and so they are receiving disability payments. Meanwhile, Because they are no longer able to work, they moved to a Medicare plan instead of continuing with a COBRA plan because of its high cost. And they also decided to add a Medicare Part D, so a prescription plan, as well as a supplement plan. So first question, what are the liens that we should be identifying here? So the first one is that ERISA plan that was in effect at the time of the accident. Probably has the hospital, maybe an ambulance, perhaps if there was a surgery or something that was pretty major within the first couple days of the hospital or of the initial hospital visit, this is going to be something that could be a large lien. So you got to know who the insurance carrier is, who the recovery vendor is, and then once you get down to it, is it self-funded? Is it fully insured? Is it going to be governed by state law or federal law? If it's self-funded and governed by federal law, are you aware of all the arguments to be made under the McCutcheon case, the Montanil case, the Amara case? Lots to consider. Now, a disability plan, also usually considered ERISA. So you got to get to the bottom of which insurance carrier, which recovery vendor is handling. Usually fully insured, but could be self-funded. So you've got to get the proper plan documents on any ERISA plan to know which it is. Then we've also got the fact that this is a Medicare beneficiary. So dealing with traditional Medicare, the government itself, and then also these Part D and supplement plans. Those are normally handled by private insurance carriers. Got to get to the bottom of who those insurance carriers are and which vendors are handling them. So when your client has lots of liens or has had varying health insurance throughout their treatment period, hiring an expert, providing us the insurance cards and letting us get to work on figuring out which one has a higher priority over another and how we can use those competing interests against each other is exactly what we do. So let's talk a little bit about the use of experts in a personal injury case. I think we can all probably agree that trial lawyers that focus on personal injury law are experts in proving causation, liability, and the overall damages of a case. But trial lawyers often require outside assistance of other experts for areas that are outside the scope of representation. And this is just a short list, but probate, guardianship, government benefit preservation, tax, bankruptcy, accident reconstruction, an economist, Medicare compliance. These are all other examples of experts that get involved in a case to assist the personal injury attorney. We can certainly add to this list lien resolution. Now, the fact is that the law governing health insurance, subrogation, and reimbursement on a personal injury settlement, it's often a litigated matter. It's complicated and it can require extensive time and effort to figure out what is what. Really, each lien type that exists, each health benefit plan that is out there is a specialized area of law all by itself. There's an ERISA statute, there's a Medicare statute, there's Medicaid statutes at the federal level and at the state level, there's military statutes, FEBA regulations. There are all sorts of different laws for each of the different lien types that might be coming at you and trying to take your client's personal injury settlement. The right is based on their own statutory and regulatory authority, so you got to know which is which and have some expert knowledge on that in order to be getting the best result. This is often governed by different states or by a federal level, or sometimes in the instance of Medicaid, a combination of the two. This is a perfect reason why you should have a lien resolution expert assisting you. Now, what if you don't hire a lien resolution company to handle a lien that is relevant to your client's settlement? What is the risk for not fully representing your client and this lien interest that's out there? Well, the client could face litigation by the lien holder. An ERISA plan could file a reimbursement action against the injured party, and you're going to have to figure out whether you're going to deal with it or not. They could also lose their health insurance coverage. If a lien is not reimbursed, there's a possibility that they choose to stop paying for future coverage. A lot of the health insurance contracts do have that wording in there, and some of them really do it. The attorney, you could face a legal malpractice claim if there is a big enough lien that all of a sudden arises that you didn't otherwise handle. We've seen that. We've had people come to us here at Synergy very upset that I've dispersed all the funds and I didn't handle this ERISA lien and now it's $200,000. What do I do? That's a tough situation, and the legal malpractice possibility is certainly there. The client or the attorney could be personally liable for double damages on a Medicare or Medicare Advantage or a Medicare Part D plan. So that's certainly a risk for not handling a lien. And the attorney could face ethical issues. We'll get into that a little bit more. Definitely depends on a state-by-state basis, and we aren't experts here at Synergy on the ethical issues for attorneys, but we're going to highlight a handful of them here coming up. All right, so for ethical issues, let's take a look at the ABA Model Rule 1.15. Got some detail here on the slide, but we'll go ahead and read it out loud as well. So paragraph E also recognizes that third parties may have lawful claims against specific funds or other property in a lawyer's custody, such as a client's creditor who has a lien on funds recovered in a personal injury action. A lawyer may have a duty under applicable law to protect such third-party claims against wrongful interference by the client. In such cases, when the third-party claim is not frivolous under applicable law, the lawyer must refuse to surrender the property to the client until the claims are resolved. A lawyer should not unilaterally assume to arbitrate a dispute between the client and the third party, but when there are substantial grounds for dispute as to the person entitled to the funds, the lawyer may file an action to have a court resolve the dispute. So this is model rules. A lot of states have duplicated or borrowed from this particular model rule, but we just want to go ahead and start with this as the beginning of our discussion as it relates to liens and an attorney's responsibility. So the other ABA model rule we want to take a look at is 1.1, which requires a lawyer to have the requisite knowledge, skill, thoroughness, and preparation necessary for lien resolution if they undertake the responsibility. So under our reading of 1.1's comments, if a lawyer lacks the necessary expertise to resolve liens, then they must ensure competent representation through other means, such as by retaining other experts, lien resolution partners like Synergy. So since resolving healthcare liens is complex from both the procedural and a legal perspective, as we just recently talked about, a personal injury attorney who lacks the knowledge and the experience and the expertise to effectively resolve those liens potentially jeopardizes the client's interest in those settlement dollars, and also creates a professional liability possibility for themselves or for their firm. So that would be the Synergy position on why you should hire a lien resolution expert. So we're going to take a closer look at a couple states. The first one that we have here is New York. There is an opinion from 2008 from their Professional Ethics Committee that specifically stated that New York lawyers were permitted to retain an outside lien resolution company and charge its fee as an expense of litigation that was ultimately paid by the client. In that opinion, with the client's informed consent, the personal injury firm could contract with the lien resolution company and assess its fee as a cost, even though the attorney was having a contingency fee arrangement. And the key was just that the fee was reasonable. The definition of the fee being reasonable was analyzed in terms of the net benefit to the client. So the example that was given in that opinion was that a lawyer who outsources complex lien problems to other attorneys, who in turn resolves it for a fraction of the lien amount, then there's ultimately a net benefit to the client. Taking a look at another state, we're going to look at Ohio. There was a 2009 opinion that said that if a plaintiff personal injury lawyer retains an outside law firm to provide healthcare lien resolution services in a settled matter, then the plaintiff lawyer may use professional judgment as to whether or not to charge the client for the service as part of the contingent fee or as an expense of the litigation. And this is something that we talked a little bit about in the very beginning. We've got clients here at Synergy that do it both ways. Depending on how they feel about it. Ultimately, do they feel like they should charge the client for the service, or do they feel like they should absorb it as part of the contingency fee? Obviously, it depends on numbers and a lot of different factors, but that is certainly up to you. So either way, the client's consent to the outsourcing, to the partnering, and the fee arrangement needed to be obtained prior to giving the lien resolution to an outside company. It was also stated that either way, the fees and expenses needed to be reasonable and not excessive. Also stated that either way, the nature and the basis of the fee arrangement needed to be communicated to the client, and the contingency fee agreement also needed to be in writing. And then if any outsourced fee is included as a part of the contingency fee, then there's a division of fee among lawyers not in the same firm that triggered a particular rule requirement. It further stated that if the outsourced service is charged to the client as a litigation expense, then the contingency fee rate must be appropriately set so as not to result in duplicative and excessive legal fees being charged to the client for a service that's being billed now separately as an expense. So again, this is Ohio's, but it's certainly something for you to take into consideration on whether you'll pass it along as a cost or whether you'll absorb it as part of your contingency fee or some combination of the two. And finally, let's take a look at Utah, as they have also directly addressed the outsourcing of lien resolution by personal injury attorneys. So this opinion was from 2014. There were two questions that they addressed. The first one was whether an attorney can ethically and appropriately outsource or partner with a lien resolution company. And then if the answer to that was yes, then the second question is, should the fees associated with that be treated as a cost to the client? So the opinion found that the answer to both of those questions was yes. As it relates to whether a lawyer can ethically outsource, they said yes, that the personal injury attorney can engage the services of a lien resolution company that can provide that expert advice, or they can associate it with a law firm that provides the service. And then for the second question, if properly disclosed in the retention agreement, then any kind of resolution service can be included as a cost to the client, as long as they are indeed professional services, and they said equivalent to accountants or appraisers. So that almost goes back to when we talked about the different places that you might otherwise hire experts, an economist, an accident reconstructionist, things along those lines. So most states have not directly addressed the outsourcing of lien resolution, but the New York, Ohio, and Utah opinions give a general framework to use when deciding to outsource, and then also whether or not to pass the fee of the lien resolution service as a case cost. Ultimately, all of these opinions find that it is permissible to partner with a lien resolution company and to pass that fee along as a case cost if the personal injury attorney's retainer agreement with the client provides that the attorney is going to do so, and the client has therefore given their informed consent. If the fees that are charged are reasonable and are passed on without any surcharge. It is permissible if the lien resolution service results in a net benefit to the client on each lien negotiated. It's permissible if the outsourcing transaction complies with state-specific bar rules, and it is permissible if the referring attorney maintains ultimate responsibility for the work product. So to summarize, why partner with a lien resolution expert? The fact is, the health insurance industry has known for decades that there's a benefit of hiring subrogation experts to handle their lien resolution. You aren't dealing with United and with Aetna and with Cigna directly. You might be dealing with some Blue Shields directly, but they still have internal units that are units of experts. These other companies, they have hired experts. They have hired Rawlings. They have hired Conduent. They have hired Optum. They have hired outside law firms, Equian, all of these different recovery agents, that this is all that they do. So they have experts on their side. So for you to have a knowledgeable lien resolution expert partner on your side helps even up that playing field. And it protects your hard work of obtaining the settlement dollars. And at the end of the day, the goal is to make sure that more money stays in your client's pocket versus going to these health insurance companies that are seeking reimbursement. It does make sense to outsource for all the reasons we've talked about here so far today, but also take note that it can be done ethically for all the reasons we've noted as well. So I wanted to highlight a recent ERISA case that came out that just focuses in on why it is that you should just partner with a lien resolution company like Synergy versus trying to take on these things on your own. All right, so we have a case here that had $18,000 in medical expenses paid by an ERISA self-funded plan. This was related to a motor vehicle accident. The ERISA self-funded plan placed the plaintiff attorney on notice of their interest prior to settling the case. The plan language for this ERISA self-funded plan said that the plan was entitled to full reimbursement, and it said that the injured party should not settle the case for less than what would fully reimburse the plan. So tricky language, but nonetheless, that is what it said. The attorney settled the case. The attorney sent a letter to the plan with a check that was less than the full amount. So we call that a drop check. But ultimately, the plan decided to keep seeking reimbursement because they did not get their full amount. The attorney, in response, just said, file closed. Our case is closed. Our file is closed. We're not sending you any additional money. So the plan filed suit against the injured person and the firm for a constructive trust, equitable lien, and a declaration of the plan's ownership in the settlement dollars was filed, as well as an order to turn over those proceeds and a request for fees and costs. The firm, in return, filed a motion to dismiss the case for failure to state a claim. So the question presented in this case is, which parties can be a defendant in an action that arises under Section 502A3 of the ERISA statute? The firm ultimately relied on a series of opinions from a sister district court, the Eastern side. And ultimately, the case they were relying on said that ERISA was silent to the issue of who could be a defendant in one of these Section 502A3 actions. And so it turned to North Carolina state law to fill the gaps. And after a review of the North Carolina state law, and absent any bad faith or negligence on the part of the attorney, the court found that the attorney could not be a defendant. In this case, the court rested its view on the theory that the attorney couldn't be sued because there was no privity of contract between the attorney and a plan fiduciary. Meanwhile, the Western District found that the Eastern District's attempt to gap fill from state law wasn't necessary, as ERISA is in fact not silent on the question of who can be sued. And so the Western District quoted Harris and found that Section 502A3 admits no limit of the universe of possible defendants. The only real limitation under that section is that they have to be seeking appropriate equitable relief. And if the fiduciary is seeking appropriate equitable relief, then anyone, including an attorney or a law firm, could be a defendant. So the finding in this particular case, the case citation is there at the top, was that the plan was indeed seeking a constructive trust or an equitable lien. And that was a good thing for the plan because they were ultimately seeking an equitable and not a legal remedy. So the Western District made 4 findings when denying the firm's motion to dismiss. The first was that the plan had shown that it was plausibly entitled to full reimbursement, that the settlement funds were identifiable and in possession of the firm, that the firm was aware of the plan's right to reimbursement, and that at the end of the day, reimbursement was not made to the plan. So this case arguably shows a split within the Fourth Circuit, and it is within the weight of authority on ERISA cases at this time. When an attorney has notice or arguably has a reason to know that an ERISA self-funded plan has an equitable lien or constructive trust, an attorney cannot just wash their hands of the lien without potentially exposing themselves or the firm to liability. And obviously this also turns into a bad client experience. So our best practice would be to enlist a lien resolution expert as your partner, such as Synergy, and allow us to work on this lien on your behalf. So at the end of the day, this is the final slide. COVID's impact is still being felt today with the reductions and the interactions that we are seeing with these various health insurance companies. So like we said before, subrogation vendors are paid bounty hunters and they require bounties to hunt. And unfortunately for them, but fortunately for people who otherwise would be injured, there were less car accidents because there were less cars on the road. There were less medical malpractice cases because there were less elective surgeries that were taking place during this time period. And I'm sure that your law firm suffered some bit of slowdown during this time period. So with these subrogation vendors whose sole existence is to find these third-party claims and seek reimbursement, they also really took the hit. Now, their clients didn't necessarily take the hit because their clients weren't paying medical claims. So the Aetnas, the Cignas, United, they weren't paying for treatment that wasn't had because of the lack of auto accidents or medical malpractices or slip and falls. But these subrogation vendors, they are the ones that are hurting. And so they are no doubt seeing their bottom line decrease. And we are seeing that they are squeezing every dollar out of every possible lien. And that means less reduction. That means more delays. That means them trying to get everything they possibly can, which makes it more difficult for you. It also makes it more difficult for us when we are fighting on your behalf. But again, a whole reason why you should hire an expert to handle this frustration. We will get the reductions if we're able to find the right cracks in the surface. At the end of the day, though, this COVID impact does leave the injured people and their advocates, whether it be you as their attorney, the paralegal or legal assistant on the case, the law firm as a whole, or Synergy, in this contentious battle to get the deepest reduction possible. But we are here and we are ready and willing to help, and we are ready for the battle. So this is the end of the presentation. Thank you for sticking around, and hopefully you are thoroughly convinced that Synergy is your lien resolution partner and that we are ready to fight on your behalf, on behalf of the injured party. So we've got our phone number here as well as our website. If you are a new client, feel free to give us a call and we will start the process with you, answer any questions that you have. If you are an existing client and we are already satisfying all your lien resolution needs, feel free to reach out to your Synergy contact, to a specialist that has already handled one of your files, or our intake department, and we will help you out on the next one. So thank you so much. Have a good one.